there's a landmark Kerala High Court judgment dealing with the meaning of the term month. My dear friends, if you go through section 107 of the GST Act, it is about appeals to appellate authority, wherein the term month is used in various subsections. This interpretation is based on section 3 subsection 35 of General Clauses Act and the Supreme Court ruling in the Himachal Techno Engineers case, AAR ruling, that is PVC floor mats for use in cars taxable at 28% affirms. My dear friends, the High Court ruled that assessee's case should be covered by section 142 subsection 3 of the CGST Act. 73 subsection 1 is a very important section under the GST Act. Since the recipient was outside India, the services qualified as exports. GST judicial outlook for the day. My dear friends, there's a landmark Kerala High Court judgment dealing with the meaning of the term month. My dear friends, month term in GST appeals means calendar month as per General Clause Act and not 30-day period held the Kerala High Court judgment. My dear friends, the first appellate authority rejected an appeal filed on 6/11/2023 against an order dated 6/7/2023. My dear friends, the order in question had treated the term month as a 30-day period under section 107 of the GST Act. My dear friends, if you go through section 107 of the GST Act, it is about appeals to appellate authority, wherein the term month is used in various subsections. The question here is whether the month represents 30 days or a calendar month is the question. My dear friends, it was held that term month actually refers to a calendar month. This interpretation is based on section 3 subsection 35 of General Clauses Act and the Supreme Court ruling in the Himachal Techno Engineers case. My dear friends, the appeal was found to have been filed within a condonable period and consequently the impugned appellate order was quashed and the matter was remanded back for fresh consideration. My dear friends, the writ petition related to this appeal was allowed. My dear friends, the landmark case is nothing but NN Steel Trading Company versus Joint Commissioner Appeals Central Tax, Central Excise and Customs, WP number 35471 of 2024. Second GST judicial outlook for the day, AAR ruling, that is PVC floor mats for use in cars taxable at 28% affirms authority for advance ruling. My dear friends, the Gujarat Appellate Authority for Advance Ruling, that is AAR, dismissed an appeal against an advance ruling authority decision. The advance ruling authority had classified PVC floor mats for car under CTH 8708 subject to 28% GST rate. The appellant argued that mat should be classified under HSN 5705, but the AAR rejected this claim as it was not raised before the authority for advance ruling. My dear friends, the AAR, that is Appellate Authority for Advance Ruling, cited the Supreme Court's dicta in the ITC case, applying the principle of res judicata, which prevents reconsideration of a matter already decided. My dear friends, the appellant's floor mats are made from PVC materials, including PVC leather, PU foam, XLPE foam, PVC mats known as heel pads. The AR's detailed reasoning in paragraph 25, which classified the product under chapter 8708, was not contested by the appellant, leading to the dismissal of their averment regarding exclusion from CTH 8708. My dear friends, Gujarat AAR in the matter of Manisha Ben Vipulbhai Soratia advance ruling number, which was concluded in the case of Manisha Ben Vipulbhai Soratia advance ruling appeal, my dear friends. GST judicial outlook 3. My dear friends, AAR remands matter to AAR for considering new facts citing scope of advance ruling. My dear friends, the Gujarat Appellate Authority for Advance Ruling has overturned an earlier advance ruling authority decision that denied exemption under serial number 3 of notification number 12/2017 for services related to preparing plans and estimates and drafting tender papers, DTP, for building works provided to the Roads and Building Department of the Government of Gujarat. My dear friends, the AAR has remanded the case back to Authority for Advance Ruling, instructing it to consider all relevant facts that were not presented during the original ruling by the appellant. My dear friends, the AAR noted that the appellant is now presenting new facts such as a list of building for which services were provided to the Roads and Building Department which were not disclosed to the Authority for Advance Ruling previously. My dear friends, the AAAR cited the scope of Section 101 of CGST Act and referred to previous AAAR ruling from Karnataka, Gujarat, Maharashtra, Andhra Pradesh, where matters were remanded back to the Authority for Advanced Ruling for reconsideration. My dear friends, the AAAR has directed the AAR to review all aspects of the case and make a fresh decision based on the complete set of facts. It was held in the matter of Devendra Kantibai Patel, Advanced Ruling number 12 bar 2025. Judicial Outlook 4. My dear friends, High Court sets aside refund or rejection of CVD and SAT paid for EO non-fulfillment post GST advent. Directs reconsideration. My dear friends, the Gujarat High Court partially allowed ASSI's writ petition. It sets aside the refund rejection relating to countervailing duty and special additional duty paid voluntarily by the assessee after failing to fulfill export obligation under the Advance Authorization and Export Promotion Capital Goods Scheme, EPCG schemes. My dear friends, the court held that under Section 142, subsection 8, clause A of the CGST Act was not applicable in this case because the assessee voluntarily deposited the duties and not as part of any recovery proceedings. My dear friends, the High Court ruled that assessee's case should be covered by Section 142, subsection 3 of the CGST Act. This section provides for considering the refund claim according to the existing law at the time of import in 2016. Therefore, refund claim should be processed. My dear friends, the refund claim should be processed under the Central Excise Act 1944, read with SENVAT Credit Rules 2004, as per the provisions of Section 142, subsection 3, read with Section 142, subsection 6, clause A of the CGST Act 2017. My dear friends, the court relied on previous decisions in cases such as Granules India Limited, Indo-Nippon Chemicals, Thermax Limited to support its rulings. It remanded the refund aspect to the revenue authorities to decide the refund claim on its merit and pass a de novo order. If the refund is found payable, it should be paid in cash as per the Thermax Limited decision. My dear friends, however, the High Court in this case upheld the rejection of Form Trans 1 filed electronically by the assessee. The assessee paid the duty foregone and CVD, countervailing duty, and special additional duty SAT only in 2008. As a result, they did not have any credit to be carried forward on 30/6/2017 when the GST was introduced in the electronic credit ledger to be utilized as input tax credit under the CGST Act. My dear friends, after paying the customs duty foregone with CVD and SAT voluntarily in 2018, due to the enactment of the GST Act, the SENVAT Credit Rules 2004 ceased to operate. Consequently, CVD and SAT, which were admissible as SENVAT credit, could not be shown in the SENVAT register, and the assessee filed Form Trans 1 electronically as per Supreme Court directing the opening of common portal for accepting Trans 1 from September 2022 to November 2022 to transfer the credit to the electronic credit ledger and alternatively claim a refund under the transitional provisions of the GST Act. Both these claims were rejected. My dear friends, it was held in Gujarat High Court judgment, Epigral Limited and others in Special Civil Application number 13695 of 2024. GST Judicial Outlook 5. My dear friends, interim stay granted on SCN issued in DRC 01 without serving notice in ASMT 10. High Court. Facts of the cases. A show cause notice was issued under Section 73 subsection 1 of CGST Act 2017. My dear friends, 73 subsection 1 is a very important section under the GST Act. Section 73 subsection 1. My dear friends, Section 73 deals with determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression of facts. My dear friends, under that subsection 1, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has been so short paid or whom the refund has been erroneously made or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with the interest payable thereon under section 50 and a penalty leviable under the provisions of this act and the rules made thereunder. My dear friends, this is about section 73 subsection 1. It has to be issued in form GSTR 01 for demand related to tax or ITC without involving fraud. Under Rule 99 of the CGST Rules 2017 in form number ASMT 10 and was not served before issuing the show cause notice. Since serving the notice in form GST ASMT 1 is prior to the show cause notice is mandatory, very important. Since serving the notice in form GST ASMT 10 prior to the show cause notice is mandatory, under Rule 99, an interim stay of all further proceedings should be granted. My dear friends, it was held in Himachal Pradesh High Court judgment, Sanmati Metals versus State of Himachal Pradesh, CWP number 1793 of 2024, my dear friends. My dear friends, last and the sixth GST judicial outlook for the day is assessee providing software services overseas qualify as export services and eligible for refund of unutilized input tax credit, held the High Court. My dear friends, the assessee provided software development and support services to a Singapore-based company, Singapore-based parent company. Very important, Singapore-based parent company. The services were directly provided on a principal-to-principal basis, not as an intermediary facilitating services between other party. My dear friends, the assessee claimed a refund of unutilized input tax credit considering the services as exports. However, revenue rejected the refund application, labeling the assessee as an intermediary. My dear friends, the service agreement clearly indicated that the assessee was directly providing services and not arranging or facilitating them. The mere receipt of a markup over cost from the parent company did not establish intermediary status. My dear friends, accordingly, under section 13 subsection 2 of IGST Act, the place of supply is determined by the location of the service recipient. Since the recipient was outside India, the service is qualified as exports. My dear friends, the court in this case held that the assessee was not acting as an intermediary but providing services direct. So the refund rejection orders were quashed and the assessee was entitled to claim refund along with the statutory interest. The writ petition was allowed. My dear friends, in this case, the refund was finally allowed. So you may have multiple questions of law. Please kindly use writ jurisdiction to question the law of the GST. My dear friends, it was held in Delhi High Court, Atlant Technologies Private Limited versus Assistant Commissioner, WP number 7530 of 2024. Thank you so much, my dear friends. I'll come out with the next set of judicial outlook shortly. Thank you.